working to get us all ready for October 1st. As our invitation mentioned, we will be having 3 sessions. We had one already, and we have today's, and then there'll be one more on the 24th at 9 a.m. Our sessions are conducted by Penny Epler-Carl. You've been introduced to Penny, of course, already. She's our state counsel. So if we've got some concerns, whether it's in Buffalo or Oswego or Rochester, Penny is the person that we go to for some good underwriting support. John Keneally is the other person that will be participating in the training. John is the Syracuse district manager and underwriting counsel. So again, there's some depth there that we can count on as we move forward through this process. I think Penny alluded to this, but this definitely will be recorded, and we can give you the information on that when we're done. And we'd like to ask for questions to be held until the end of the meeting. So again, thank you, everyone, and I'll turn it over to Penny.
Okay, good morning, everybody. So as I mentioned, there's actually 3 handouts for this presentation that you can get directly from the direct operations. 2 of the handouts are just, they were prepared by Alta, and they're just a comparison chart for both the owners and the loan policy. And the 3rd handout is an underwriting memo issued by the company regarding Passapaca Trust, and we'll get into more of that as we go through. So let's get started. All right, the first thing I need to do is to make a correction and clarification to the talk that I gave on Tuesday. So here's our scenario. We've got a construction loan policy that was issued prior to October 1st, and it's got affirmative coverage on Schedule B. The lender is now requesting a title rundown in order to disperse construction loan draws after October 1st. When you're doing the title rundown for a construction loan draw, it is permissible to use that Tersa construction loan policy endorsement and bring the date of the loan policy forward to your effective date of this search without stripping out the affirmative coverage from the exceptions in the policy. So even though we've issued the policy before October 1st, and now we're bringing the date of that policy forward after October 1st, that affirmative coverage can still stay in the policy. What is not permissible is to give any new affirmative coverage for any kind of new exceptions that might be raised under that construction loan policy endorsement. That affirmative coverage can be provided by the applicable and available endorsements, and you would need to collect the related fee for that endorsement at the time that you issue your construction loan policy. So I just wanted to clarify and correct some statements that I made from Tuesday. So that's just a clear up from that. So we'll get started on today's presentation. And what we're going to do is we're going to go over the policy jacket, the covered risks, the exclusions from coverage, Schedule A and Schedule B, and the conditions of the policy jackets. Now I'm going to cover both the owners and the loan policy simultaneously. So what I've done is I've built in some visual cues. If what I'm talking about only applies to the owner's policy, you're going to see the green font in the heading area. If it only applies to the loan policy, you're going to see that yellow orangish font in the top, just to cue you in on which one of these policies I'm talking about. If it covers both, you're not going to see any different coverage, any different colors. So in the new jacket, there's introductory language that basically eliminates the need for that policy authentication endorsement because it's being incorporated directly into the policy jacket. So as long as the insurer issues a policy with a policy number and a date of the policy is valid, even if it's issued electronically or without a signature. So we'll get started in our covered risks. So covered risk number 2 is both improved and has new coverage. So the improved coverage you're seeing in the blue font, and basically it's bringing in the remote online notarization that we're all seeing a little bit more of since COVID. So the owners and loan policies update covered risk number 2 by clarifying existing and adding new coverage for certain title defects that cause a covered loss. So 2A, um, 3Is, a document affecting the title not properly authorized, created, executed, witnessed, sealed, acknowledged, notarized, including by remote online notarization or delivered. And 2A4, again, it is just it's saying that we're not excluding coverage if the document was signed by electronic signature, or the signature wasn't valid under the applicable electronic transaction law. The new part of the coverage for covered risk number 2 is that the survey coverage provided in covered risk 2C also is enhanced to add boundary line overlaps as one of the matters covered if it would have been shown on a survey. So our survey coverage is a little bit improved in the new 2021 policies. All right, for covered risks number 5, 6, and 7, they're broadened. And the policies include this new term called enforcement notice, and it's covered in the definitions. But enforcement notice, and together with a refinement of the definition of public records, there's a clarification regarding the type of notice that triggers coverage and where that notice needs to be recorded. Both the owners and loan policies revised covered risk 5, 6, and 7 for losses resulting from a violation or enforcement of governmental regulations, enforcement of other governmental powers, or the exercise of power of eminent domain. The updated language covers losses to the extent the violation or the enforcement or exercise described in an enforcement notice. The other broadened coverage is environmental protections now expressly include environmental remediation. So what is this enforcement notice? The document must be recorded in the public records, and it must describe the land or part of the land, and is issued by a governmental agency and identifies a violation or enforcement of a law, ordinance, permit, or governmental regulation. Or it's issued by the holder of a power of eminent domain or a governmental agency that identifies the exercise of a governmental power, or asserts a right to enforce a Paca Pasa trust. And we're going to get into what that is in a second here. I just want to note, so public records include the county clerk's records, but it does not include any other filing system pertaining to environmental remediation or protection or planning or permitting or zoning, license, building, health, public safety, or national security. So what we're talking about is this document that is, it would be qualified as an enforcement notice, and it has to be in the county clerk's records. So how is this broadened coverage affected by the exclusion from coverage section in the jacket? So remember, when we're trying to determine what our covered risks are, we always have to juxtapose it hand in hand with the exclusion section. So the policies still exclude coverage for matters related to violations relating to building and zoning, subdivision, environmental remediation, protection, eminent domain. But if the search finds a document that qualifies as a violation and qualifies as an enforcement notice, it must be specifically accepted on Schedule B. So what would that be? I think the most common thing, and you don't see a lot
Hey, how
of
are
them,
you?
but
Good.
could you go ahead
Did
and
Daryl
mute,
tell
please?
us to stand down or pens down, or are we moving
I'm
forward?
not sure who's talking, but
What
can
am
you
I,
go
you know,
ahead and
I
mute
don't, am I
yourself?
emailing Michelle with the,
Thank you. All right, let's talk about this again. So the most common thing that you're going to see is some sort of environmental spill or something where DEC has filed something in the county clerk's records regarding covenants and restrictions on how the land is used. You find one of those, you've got to specifically accept it on Schedule B. Now, as I talked about public records, there is no requirement to do additional municipal searches to try to find these things. But if they're run and defects are found, for the meantime, I would suggest that you raise them on Schedule B. Why is that? I just told you that it's not a covered risk if they're not in the public records. Well, insurance is a contract of indemnity. And under contract law, we're the drafter of that. So if there is a claim, matters are going to be construed against us and in favor of the insured. So if we have knowledge of it because we did these muni searches, I think for the short term here going forward, we're deemed to have knowledge. So why didn't we raise it as an exception? I think that's how a court might look at that. Until we've got some case law on it, I think it's prudent that if we find these things in our muni searches, that we make sure that we're raising them on Schedule B, even though they wouldn't meet the definition of a covered risk and they would be excluded from the exclusion coverage in the jacket. Covered risk number 8. This is new coverage. So both policies have added new coverage that ensures against enforcement of these PACA PASA trusts, but only to the extent of the enforcement described as an enforcement notice. PACA PASA trusts is also a new defined term in the policy jacket. So PACA is the Perishable Agricultural Commodities Act. And it imposes a trust for unpaid suppliers, sellers, and agents of fresh fruit, fresh vegetables. The PASA Trust is the Packers and Stockyard Act, and it establishes a similar trust on assets of packers to protect livestock producers. Both of these trusts exist in unrecorded forms. So one of the handouts that I provided to your direct operations is an underwriter bulletin on this. So a PACA PASA trust are claims that are superior to all other creditors. And as I just mentioned in the previous slide, they don't have to be recorded to be a valid claim. Thus, lenders and of purchase money mortgages, refinance mortgages, or construction loan mortgages may have exposure to a pre-closing unpaid PACA PASA claim. When you're insuring the purchase of lease of when you're insuring the purchase or lease or financing of any property that is either by an agricultural user or a restaurant or a grocery store or a stockyard, cattle, pig farm, the following exception must be raised in an owner's or loan policy. And this exception is in that underwriting memo that I mentioned earlier. Now, so we've got this new coverage. In my 20 plus years of title insurance, I've never seen a PACA PASA trust. So I don't really think this is going to be a big deal. John, have you ever seen any?
No, I have
Yeah.
not. So
Yeah, these are not common things. And again, remember, it under the PACA PASA trust laws, they are valid claims, but in order to be a title, a covered risk, it's got to be recorded. Remember, it's got to be enforcement. It has to meet that definition of enforcement notice, and it's got to be in the public record. So I really don't think this new coverage is gonna affect our everyday transactions all that much. All right, covered risk number 9, and this is for loan policies, okay? Is both improved and broadened. In the 2021 loan policy, updated coverage, covered risk number 9, there's new instances that can impair the insured mortgage and cause a covered loss. The insured mortgage not being properly authorized, created, executed, witnessed, sealed, acknowledged, notarized. And here we go. The new language, a new portion of this is includes the remote online notarization or delivered, as well as the invalidity or unenforceability of the insured mortgage resulting from the reputed of an electronic signature by a person who signed the mortgage because the signature was not valid under applicable electronic transaction law. So it's just broadened coverage and it's improved because it's specifically now referencing the remote online notary portion of it. So they've got a little bit more coverage now because we're also covering those mortgages that were executed remotely. Covered risk number 9. Now this is owner's policy only, and it's improved. Improved creditors' rights covered relating to transactions occurring prior to the insured transaction. So it clarifies the coverage by insuring against loss or damage by a court order providing an alternate remedy. And this is like section 550A of the bankruptcy code, an alternate remedy allowing the bankruptcy trustee to recover the benefit of the estate, the property transferred, or if the court so orders, the value of such property. Updates the coverage by insuring against loss or damage resulting from prior transactions being voidable under Uniform Voidable Transaction Act. Now in New York State, this is in the debtor-creditor law. Article 10 has the provisions for the Uniform Voidable Transaction Acts. It also clarifies the meaning of failure to record timely. So your closing happened and you wait 2 or 3 weeks before you even send your documents to the county clerk. That I think that would qualify as failure to record timely. You close today and tomorrow you send your documents out to the county clerk, but this particular county has a lag time of 3 weeks. That is not failure to record timely. What we need to focus on is when they're sent to the clerk. We're not going to be penalized because the clerk has backlog and they don't go on record right away. We have to be able to prove that they were sent timely to the clerk. Covered risk number 10 of the loan policy is clarified. Now explicitly ensures the priority of the insured mortgage as to specific components of the indebtedness, including the amount of principal dispersed as of the date of policy, the interest on the obligation secured by the insured mortgage, the reasonable expenses of foreclosure, amounts advanced for insurance premiums by the insured before the acquisition of the estate or interest in title. The following amounts advanced by the insured before the acquisition of title to protect the priority of the lien of the insured mortgage. For instance, real estate taxes and assessments imposed by a governmental taxing authority, and regular periodic assessments by property or homeowners association fees. So those are the two two things that like a lender would need to make sure get paid if the borrower isn't paying them, to protect their mortgage interest in the property, because governmental agencies and homeowners association can bring foreclosure action to foreclose on the property. Covered risk number 13, loan policy has been improved. There is improved creditors' right coverage in covered risk number 13. The protection against loss resulting from a court order providing an alternative remedy now applies to both subsection of covered risk of this covered risk. So again, this is the Bankruptcy Code section 550A that authorizes remedy allowing the bankruptcy trustee to recover for the benefit of the estate, the property transferred, or if the court so orders, the value of such property. In addition, the provisions of this broadened covered risk also include updated coverage by insuring against loss resulting from prior transfers being voidable under the Uniform Voidable Transaction Act. All right, so we've covered our covered risks. Now we're going to go into the exclusion from coverage section of our policy jackets. Both the owners and loan policies have two new exclusions. The remaining changes to the exclusion section consists of updating and making them consistent with the revised language corresponding to the covered risk section and the conditions section. For example, in addition to excluding loss resulting from municipal regulations, exclusion 1 revises subsection B to exclude loss or damage resulting from any governmental forfeiture, police, regulatory, or national security power. Exclusion risk number 3, improve coverage. Now that's kind of sounds contradictory there, because we're excluding from coverage, so how can it be improving coverage? Here's how. Exclusion 3 modifies the language to exclude loss or damage that would not have been sustained had the insured paid consideration sufficient to qualify as a bona fide purchaser or encumbrancer under applicable recording laws. So the coverage is improved because it's no longer excluding from coverage matters based on the insured's failure to pay reasonable or fair market value. So they've taken that was a condition in the 2006. It is not a condition in the 2021. So that's how it's improved coverage. They no longer have to prove the insured no longer has to prove that they paid reasonable or fair market value. Exclusion 6 from the loan policy is the same as exclusion 4 from the owner's policy. The creditor's rights exclusion in each policy contains clarifications that loss resulting from avoidable preference is excluded if not given as a concurrent exchange for new value. Also contains an express exclusion for loss resulting from the transaction vesting the title or creating the insured mortgage being a voidable transfer under the Uniform Voidable Transaction Act. So if you're not familiar with New York State debtor creditor law, Article 10, take some time and review that, because it really is integrated in these 2021 policies, both in the covered risk section and in the exclusion section. So you really need to have a pretty good understanding of that section of law. A new exclusion It's number 7 in the loan policy, number 5 in the owner's policy. Both policies include a new exclusion for the loss arising from the claim of a PACA PASA trust, while stating that exclusion does not modify or limit the coverage provided in the new covered risk number 8. Covered risk number 8 in both policy forms insure against the loss resulting from the enforcement of the PACA PASA trust, but only to the extent the enforcement is described in an enforcement notice document and it's in the public record. So this is our exclusion that covers us. Remember, those PACA PASA trusts are a valid claim, even if they're unrecorded, but for purposes of title insurance, in order for them to claim damage or loss, they're only covered if we missed it, and it's an enforcement notice document that's in the public record. Exclusion number 6 of the owner's policy. It's similar to the 2006 policy, but the 21 policy does not insure against real property taxes and assessments that become due and payable after the date of the policy, whether before or after the recording of the deed or instrument of transfer. So we're right in the period right now where this this exclusion provision applies. Well, we're the end of August, we would have been in that. So this is an instance for school taxes, right? They're a lien as of July 1st, but oftentimes in most jurisdictions, they're not due and payable till sometime in September. So this exclusion is just kind of broadening it, that we're running from the effective date of the policy. It doesn't matter when the deed goes on record. So if you've got those school taxes that are not yet due and payable, you're raising those on Schedule B unless you've taken an escrow for them. Exclusion 6 does not affect the coverage, the covered risk 2B, which insures against real property taxes and assessments due and payable but unpaid. Exclusion 7 of the owner's policy and 9 of the loan policy. This is also another new exclusion for loss caused by any discrepancy in the quality and the quantity of the area, square footage, or acreage of land or any improved land. So we now have a specific exclusion for our acreage. This new exclusion does not change the need to include a clarification or a notice statement on Schedule A. So in your legal description, if you've got a recital that's reciting acreage, you can't rely just on this new exclusion that we're not insuring acreage. Remember, we insure on Schedule B, we insure on Schedule A, we take away insurance on Schedule B. So if you've got an acreage recital on Schedule A legal description, you need to qualify it. You can't just rely on this new exclusion, because that's where we're insuring it on. You should include some sort of limiting language before that acreage recital. For conveyance purposes only, acreage is not insured containing 100 acres of land, more or less. All right, so we're done with our covered risks and our exclusions, and we're going to move on to Schedule A and Schedule B. So both Schedule A of the loan policy and the owner's policy have got some new updates. There's an optional transaction identification data header that's been added to Schedule A to provide some clarity and to make post-closing smoother and general inquiries easier. This information is intentionally set apart from the insuring information on Schedule A, so it's not an insured matter. but it serves as reference information to improve communications between the insurer and the customer. So you'll see the loan policy is the orange yellow header, and the owner's policy is the green, and it just says who was the agent, who is the office, maybe there's a loan ID number, a property address. Okay, so that's basically the only change to Schedule A. Everything else is the same as the 2006. But we do have some new provisions in Schedule B. Schedule B will begin with the following sentence. Some historical land records contain discrimination covenants that are illegal and unenforceable by law. This policy treats any discriminatory covenant in a document referenced in Schedule B as if, I'm sorry, I lost it. In Schedule B, each discriminatory covenant is redacted, reputed, removed, not republished, or recirculated. Only the remaining provisions of that document are accepted from coverage. So what does this mean? This language removes the need to add to the exception for the restrictions that may be unenforceable or discriminatory provisions. For example, we would raise a covenant and restriction in book whatever, page whatever, but omitting any covenants or restrictions if or including but not limited to those based on race, color, religion, sex, sexual orientation, yada, yada, yada. We no longer have to put that in the exception. Okay, so now we can just say covenants and restrictions. If it has some sort of title, list it in book whatever, page whatever. We don't need to exclude those race matters or religious matters anymore in the exception. Here's the caveat. This new provision does not affect the need to redact all that discriminatory restrictions from a recorded document before you provide them as an exhibit to the title report. That's a federal law. You can't you can't disseminate documents that have these discriminatory covenants in them. You need to redact them before you provide them to the customer as an exhibit to your exception on Schedule B. All right, Schedule B of the loan and owner's policy. The new policies also provide the lead-in sentence immediately preceding the list of exceptions. This new lead-in sentence is, the policy does not insure against loss or damage, and the company will not pay costs, attorney's fees, or expenses resulting from the terms and conditions of any lease or easement identified in Schedule A and the following matters. So what does this mean? This new addition removes the need to include specific exceptions for terms and conditions in a lease or an easement that comprise all or part of the insured land. For example, now when we're putting a lease as an exception on Schedule B, we can simply raise it as follows. Lease made by and between Rosie the Robot and George Jetson, dated July 28, 2024, as evidenced by a memorandum of lease recorded July 28, 2024, Spacely Sprockets County, County Clerk's Office, instrument number, whatever. So it's simplifying the way that we're raising either leases or easements in the fact that we no longer need to put terms and conditions in front of that exception. And so this is what the Schedule B looks like both on the loan and owner's policy going forward. And you'll see those two new paragraphs under the title exceptions from coverage. All right, let's get into the conditions section of our policy jacket. So in the conditions, that's where we've got our definition of terms. There are several noteworthy revisions and additions to the definition of terms. Affiliate, discriminatory covenant, enforcement notice, Pacapasa Trust, state, are new in both policy forms. There substantial revisions have been made to the other terms such as insured and public records. So those insured and public records were pre-existing terms, but there's been substantial revisions made to both of those, and let's get started. So affiliate is a new term in both policies, and it's an entity that is wholly owned by the insured, that wholly owns the insured, or if that entity and the insured are both wholly owned by the same person or entity. Affiliate will be considered an insured when the name insured conveys title to that affiliate by deed or other instrument of transfer. So it's kind of broadening. It's similar to the 2006, but it's kind of broadening the fact that the policy an owner's policy may continue. So if there was a transfer and that new person meets the definition of affiliate, then the owner's policy may still continue to be in effect. So this is a new term in the loan policy. They've added consumer protection law. They've basically the loan policy features a new definition of term for consumer protection law that replaces the term consumer credit protection law and truth in lending used in exclusion 5 of the 2006 Alta policy. So they're just catching up with the time with the change of the consumer protection law. This is for the loan policy. There's a new loan, the new loan policy also makes changes to the definition of insured. This additional language in the loan policy does not alter the coverage, but it does clarify that the insured is a person or entity that holds title after acquiring the indebtedness, regardless of the meaning of acquisition. In the loan policy, a transfer from the named insured to one of the following can result in the grantee being an insured under the policy. So again, this is a it allows for a continuation of a loan policy after transfer. The grantee of the insured under a deed or other instruments transferring the title if the grantee is an affiliate. And here's a note that it no longer needs to be for there's no longer a condition for the transfer to be for no consideration. An affiliate that acquires the title through foreclosure or deed in lieu of foreclosure of the insured mortgage, regardless of whether the affiliate owned or held the indebtedness or any governmental mortgage agency or instrumentality. So this is basically broadening the fact of it's defining the terms for under which the loan policy can continue to be effective if the named insured has changed, as long as they've meet these 3 requirements. This regards to the owner's policy. The new owner's policy. And in the new owner's policy, a deed from the named insured to one of the following can also result in the grantee being an insured under the policy. So if you've got a trustee or a beneficiary of a trust created by a written instrument established for estate planning purposes by the insured. So if I own my property, I set up a trust for estate planning purposes, and I transfer my property to the trustee of my trust. my owner's policy will continue. The next one is a spouse who receives title because of the dissolution of a marriage or a transferee by a transfer effected on the date of on the death of the insured as authorized by law. So again, if my husband and I have an owner's policy and then we're divorced, my owner's policy and that he transfers title to only me, my owner's policy is going to continue. If I own if I own the property and my daughter is my sole heir, and upon my death, she inherits the property, my owner's policy is going to continue to cover her as well. And the third category is another insured named in Schedule B as named in item 1 of Schedule A. So this is, you're not gonna see a lot of this in residential, but like sometimes on our low-income housing projects, we'll have 2 different named insureds. They'll have the fee simple, bare legal title holder and a nominee. So that's where the policy would continue to cover both the both named insured on Schedule A, item number 1. These last 2 categories are new, and this provision also is different from the corresponding language in the 2006 policy because there's no requirement that there's a deed or a conveyance that is for no consideration. Okay, so we've got a new, this relates to loan policies. There's a defined term, government, mortgage agency, or instrumentality. The loan policy features a new definition for the term of government, mortgage agency, or instrumentality, a term that does not impact coverage, but is used in the definition of insured or obligor. Government, mortgage agency, or instrumentality is not an obligor. There's a new definition for obligor. The loan policy features a new defined term for obligor, defined as a person or an entity that is or becomes a maker, borrower, guarantor as to all or part of the indebtedness or other obligations secured by the insured mortgage. Again, I say the government, mortgage agency, or instrumentality is not an obligor. The term obligor is used principally in condition 12 of the loan policy, which covers the right of recovery on payments or settlement. But condition 12 of the 2006 and the 2021 Alta policy remain substantially the same. Again, we talked about the definition for public records. The 2021 policy provides modification to this definition of public record, and it clarifies and distinguishes between those records that are public for the purposes of the terminology used in the title policy and other governmental records that are not intended to be and generally are not construed as being within the scope of public records for the purposes of triggering coverage in the policy. So what do I mean here? I mean, obviously, if you're doing municipal searches, most people would think those are public records. However, we're defining a term in the policy which triggers coverage or exclusion. So for all intents and purposes, public records are county clerk's records. Condition 8 is the heading is contract of indemnity, determination and extent of liability. this one there's some significant changes here. And hopefully, that in the condition section, generally speaking, this is what you need to know when you go to make a claim. But it's good information to have in the back of your head when you're underwriting things. Um, some significant changes. The conditions clarify that the policy is a contract of indemnity. Within an initial statement that the policies are not abstracts of title, they're not reports, they're not legal opinions or opinions of title or other representations of title. Among the improvements in the coverage are the provisions establishing a procedure for the insured to select the date for determining the value for purposes of calculating loss. The ability to choose an alternative date for the determination of loss is no longer conditioned on the insured's unsuccessful attempt to cure the defect. So it does give the insured some benefits of when they can select the date for determining what their loss is. Condition 8, again, we're still, this is only for the loan policy. The new loan policy provides options for the insured to determine loss regardless of any action taken on the part of the insured. Fair market value of title is calculated by using either the date the insured acquired title as a result of a foreclosure or a deed in lieu of foreclosure of the insured mortgage, or the date the lien of the insured mortgage or any assignment set forth in item number 4 of Schedule A is extinguished or rendered unenforceable by matters insured against in this policy. So let's say there was a total failure of priority of that mortgage. Those are by one of the covered risks. They can select the date of the lien or the date the lien was assigned as their point for calculating the value, the fair market value of title. In addition, a new subsection provides additional alternatives to the insured claimant if the insured attempts to establish title but is unsuccessful. The amount of insurance will be increased by 15%. Now, in the prior 2006, that was 10%. So now they've got the amount of insurance will be increased by 15%, and the insured claimant may elect to use either the date of settlement, action, or proceeding is when the proceeding is concluded, or the date the notice of the claim is recovered by the insured as the date for calculating fair market value. So this is condition 8 for the owner's policy. In the owner's policy, while the terms regarding the extent of liability remains essentially the same, a revision of a subsection addresses the valuation and states the fair market value of title is calculated using the date the insured discovers the defect or other matter insured against by this policy. So it's setting forth the date where we're pinning down when we're going to determine the value. However, if the date of the policy the title to all of the land is void by reason of matter covered by the policy, then the insured claimant may make written notice given to the insured to elect the date of the policy as the date for calculating the fair market value. If the insured does pursue the right to cure the title is unsuccessful, the amount of insurance will be increased by 15%. Again, in the prior it was 10, so there's a 15% increase. The insured claimant may elect to use either the date of settlement, action, or proceeding it is concluded or the date the notice of claim is received by the insured as the date for calculating the fair market value. So, you know, if we've got a fluctuating real estate market, these dates are important. And I think the two big takeaways from the changes in condition 8 for both the owners and loan is the fact the amount of the insurance increase from that 10% in 2006 to 15% in the 2021 policy. All right, condition number 10 of the loan policy. Loan policy now entitles a reduction or termination of insurance, improves the coverage of the loan policy by adding a new subsection B that states, when title is acquired by the insured as a result of a foreclosure or a deed in lieu, the amount credited against the indebtedness does not reduce the amount of insured. So, basically, if in the 2006, we would reduce the amount of their insurance, you know, like in any typical loan policy, as the loan gets paid down, right, the value of the policy decreases. Here it's saying we're not going to reduce the amount of the insurance. When the title is acquired as a result of a foreclosure or deed in lieu. So we're not applying a credit against the value of the insurance in those situations. Condition 15 of the loan policy and 16 of the owner's policy. The 2021 policy contains a revision in the choice of law provision in the loan policy. 15A and 16A of the owner's policy clearly provide that state law of the state where the land is located, or to the extent controls federal law, will determine the validity of the claim against title or the enforcement of the policy. So here it's just saying New York is going to be the choice of law that we're going to use to determine matters between whatever claim the insured is making against the insurer. Condition 17 of the loan policy and 18 of the owner's policy. So this is a new condition. So the 2021 policies contain a new condition entitled class action as a separate condition. It allows for claims and disputes must be brought. It says that claims and disputes must be brought in an individual capacity and may not be brought as a class action suit against the title insurer. Condition 18 of the loan policy, 19 of the owner's policy is the arbitration condition. Although the optional arbitration condition has been substantially revised in the 2021 policy, the provision remains pretty similar to those that were in the 2006 policy. Claims and disputes must be brought in an individual capacity and may not be brought as a class action. So that's true for if you're doing just a general claim, or if you're electing to bring your claim through arbitration, you've got to do it as an individual. You can't do it as a class action matter. Okay, so we've got about 5 minutes. If anybody has some questions, feel free to unmute yourself. Before we do that, John, is there anything you want to fill in or add or clarify a point that I've covered?
No, I think you've covered everything
Okay.
pretty well. I have nothing to add, so thank you.
Okay, so if anybody has any questions